This is part 42 as far as our lecture series is concerned. During the last part, we concluded provisions regarding trial by taking into consideration various trials, namely trial before a court of session, trial of warrant cases by magistrate, trial of summons cases by magistrate, and summary trials are the trials with which we dealt. And there we learn trial always results into either conviction or acquittal, and the purpose of the trial is to record the evidence in order to find out guilt or innocence of an accused person, barring only one case, namely discharge. In the rest of the cases, the trial always results into either conviction or acquittal. The distinction between discharge and acquittal we have to take into consideration in order to understand section 300 of the Criminal Procedure Code, which is based on the maxim autor fois acquit or autor fois convict, with which we shall be dealing during course of time. But the decision of the court is by pronouncement of the judgment. And at the time of discussing trial, I refer to some of the sections as far as judgment is concerned. But this is a time, in today's lecture, we will try to understand in detail everything regarding judgment. And when we refer to chapter 27 of the Criminal Procedure Code, and it starts right from section 353 up to section 365 of the Criminal Procedure Code, we understand the importance and various aspects as far as the judgment is concerned. Section 353, it says, the judgment in every trial in a criminal court of original jurisdiction shall be pronounced in open court by the presiding officer immediately after the termination of the trial, or at some subsequent time of which notice shall be given to the parties or their pleaders. And how this notice is required to be given, or how the judgment is required to be pronounced, by delivering the whole of the judgment as per small a of section 353, or by reading out the whole of the judgment, or c, by reading out the operative part of the judgment and explaining the substance of the judgment in a language which is understood by the accused or his pleader. So this is the manner in which a judgment is required to be. The judgment in every trial in any criminal court of original jurisdiction shall be pronounced in an open court by following as far as clause small a, small b or small c of subsection 1 of 353 of the Criminal Procedure Code is concerned. Subclause 2 says, where the judgment is delivered under clause small a of subsection 1, the presiding officer shall cause it to be taken down in shorthand and sign the transcript and every page thereof as soon as it is made ready. Write on it the date of the delivery of the judgment in open court. Where clause 3 says, where the judgment or of the operative part thereof is read out under clause small b or clause small c subsection 1, as the case may be, it shall be dated and signed by the presiding officer in open court, and if it is not written with his own hand, every page of the judgment shall be signed by him. Clause 4 says, the judgment is pronounced in the manner specified in clause small c of subsection 1. The whole judgment or a copy thereof shall be immediately made available for the perusal of the parties or their pleader free of cost. Subclause 5 says, if the accused is in custody, he shall be brought up to hear the judgment pronounced. Clause 6 says, if the accused is not in the custody, he shall be required by the court to attend to hear the judgment pronounced, except where his personal attendance during the trial has been dispensed with and the sentence is one of fine only, or he is acquitted, provided that where there are more accused than one, and one or more of them do not attend the court on the date on which the judgment is to be pronounced, the presiding officer may, in order to avoid undue delay in the disposal of the case, pronounce the judgment notwithstanding their absence. Subclause 7 says, no judgment delivered by any criminal court shall be deemed to be invalid by reason only of the absence of any party or his pleader on the day or from the place notified for the delivery thereof, or of any omission to serve or defect in serving on the parties or their pleaders, or any of them the notice of such day and place. And clause 8 says, subclause 8 says, nothing in this section shall be construed to limit in any way the extent of provisions of section 465 of the Criminal Procedure Code. Now the next section, namely section 354, says language and contents of the judgment. It says, except as otherwise expressly provided by this code, every judgment referred to in section 353 shall be written in the language of the court. And what is the language of the court? For that we had reference at the time of the trial as far as section 272 of the Criminal Procedure Code is concerned. B shall contain the point or points for determination, the decision thereon, and the reasons for the decision. Small c shall specify the offence, if any of which, and the section of the Indian Penal Code or other law under which the accused is convicted, and the punishment to which he is sentenced. D, if it be a judgment of acquittal, shall state the offence of which the accused is acquitted, and direct that he be set at liberty. Subclause 2 says, when the conviction is under the Indian Penal Code and it is doubtful under which of the two sections or under which of the two parts of the same section of that code the offence falls, the court shall distinctly express the same and pass judgment in the alternative. Subclause 3 says, when the conviction is for an offence punishable with death, or in the alternative with imprisonment for life, or imprisonment for a term of years, the judgment shall state the reason for the sentence awarded, and in a case of sentence of death, special reasons for the sentence. Subclause 4 says, when the conviction is for an offence punishable with imprisonment for a term of 1 year or more, the court imposes a sentence of imprisonment for a term of less than 3 months. It shall record its reasons for awarding such sentence unless the sentence is one of imprisonment till the rising of the court, or unless the case was tried summarily under the provisions of this code. Subclause 5 says, when any person is sentenced to death, the sentence shall direct that he be hanged by the neck till he is dead. Subclause 6 says, every order under section 117 or subsection 2 of section 138 and every final order made under section 125, section 145 or section 147 shall contain the point or points for determination, the decision thereon, and the reasons for the decision. With this now, section 355 of the Criminal Procedure Code deals with the cases where the judgment is by a metropolitan magistrate, and it says metropolitan magistrate judgment, and it's made very clear, instead of recording a judgment in the manner herein before provided, a metropolitan magistrate shall record the following particulars, namely the serial number of the case, the date of the commission of the offence, the name of the complainant if any, the name of the accused person and his parentage and residence, the offence complained of or proved, the plea of the accused and his examination if any, the final order, the date of such order, in all cases in which an appeal lies from the final order either under section 373 or under subsection 3 of section 374, a brief statement of the reasons for the decision. And then section 356 deals with the cases where order for notifying address of previously convicted offender, and it says, when any person having been convicted by a court in India of offence punishable under section 215, section 489 capital A, section 489 capital B, section 489 capital C, or section 489 capital D, or section 506 in so far as it relates to criminal intimidation punishable with imprisonment for a term which may extend to 7 years or with fine or with both of the Indian Penal Code, or of any offence punishable under chapter 12 or chapter 16 or chapter 17 of that code with imprisonment for a term of 3 years or upwards, is again convicted of any offence punishable under any of those sections or chapters with imprisonment for a term of 3 years or upwards by the court other than that of a magistrate of the second class, such court may, if it thinks fit, at the time of passing a sentence of imprisonment on such person, also order that his residence and any change or of absence from such residence after release be notified as hereinafter provided for a term not exceeding 5 years from the date of the expiration of such sentence. Subclause 2 says, the provisions of subsection 1 shall, with reference to the offences named therein, apply also to criminal conspiracies to commit such offences and to the abatement of such offences and attempt to commit them. Subclause 3 says, if such conviction is set aside on appeal or otherwise, such order shall become void. Subclause 4 says, an order under this section may also be made by an appellate court or by a high court or by a court of session when exercising its power of revision. Subclause 5 says, the state government may by notification make rules to carry out provisions of this section relating to the notification of residence or change or absence from residence by release convict. And lastly, subclause 6 says, such rules may provide for punishment for the breach thereof, and any person charged with a breach of any such rule may be tried by a magistrate of competent jurisdiction in the district in which the place last notified by him as his place of residence is situated. With this now, there are now section 357, section 357A, section 358 and section 359 deal with where the court passes an order for compensation. Now, section 357, order to pay compensation. It says, when a court imposes a sentence of fine or a sentence including a sentence of death of which fine forms a part, the court may, when passing judgment, order the whole or any part of the fine recovered to be applied A. in defraying the expenses properly incurred in the prosecution, B. in the payment to any person of compensation for any loss or injury caused by the offence when compensation is, in the opinion of the court, recoverable by such person in a civil court, C. when any person is convicted of any offence by having caused the death of another person or having abated the commission of such an offence in paying compensation to the person who are, under the Fatal Accidents Act 1855, entitled to recover damages from the person sentenced for the loss resulting to them from such death. Clause D says, when any person is convicted of any offense which includes theft, criminal misappropriation, criminal breach of trust, cheating, or of having dishonestly received or retained, or having voluntarily assisted in disposing of stolen property, knowing or having reason to believe to be same to be the stolen, is in compensating any bona fide purchaser of such property for the loss of the same, if such property is restored to the possession of the person entitled thereto. Subclause 2 says, if the fine is imposed in a case which is subject to appeal, no such payment shall be made before the period of allowed for presenting the appeal has elapsed, or if an appeal be presented before the decision of the appeal. Subclause 3 says, when a court imposes a sentence of which fine does not form a part, the court may, when passing judgment, order the accused person to pay by way of compensation such amount as may be specified in the order of the person who has suffered any loss or injury by reason of the act for which the accused person has been so sentenced. Clause 4 says, an order under this section may also be made by an appellate court or by the High Court or Court of Session when exercising its power of revision. Subclause 5 says, at the time of awarding compensation in any subsequent civil suit to the same matter, the court shall take into account any sum paid or recovered as compensation under this section. With this now, when we start discussing the next section, namely when the victim compensation, which section 357A, which deals with victim compensation scheme. In order to understand this section, first of all, it is necessary for us to know who is victim. And then if you go back to section 2, which is a defining section, and read small wa, which define victim, which it says victim means a person who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir. So this is as far as the victim is concerned, and section 357A deals with victim compensation scheme. It says, every state government in coordination with the central government shall prepare a scheme for providing funds for the purpose of compensation to any victim or his dependents who have suffered loss or injury as a result of the crime and who require rehabilitation. Subclause 2 says, whenever a recommendation is made by the court for compensation, the District Legal Services Authority or the State Legal Service Authority, or as the case may be, shall decide the quantum of compensation to be awarded under the scheme referred to in subsection 1. Subclause 3 says, in the trial court, at the conclusion of the trial, is satisfied that the compensation awarded under section 357 is not adequate for such rehabilitation, or where the cases end in acquittal or discharge and the victim has to be rehabilitated, it may make recommendations for compensation. Clause 4 says, where the offender is not traced or identified, but the victim is identified, and where no trial takes place, the victim or his dependents may make an application to the state or the District Legal Services Authority for reward of compensation. On the receipt of such compensation or on the application under subsection 4, the state or the District Legal Service Authority shall, after the due inquiry, award adequate compensation by completing the inquiry within 2 months. Subclause 6 says the state or the district legal services authority, as the case may be, to alleviate the suffering of the victim may order for immediate first aid facility or medical benefits to be made available free of cost on the certificate of the police officer not below the rank of officer in charge of the police station or a magistrate of the area concerned, or any other interim relief as the appropriate authority deems fit. With this, as per section 358 of the Criminal Procedure Code, compensation is to be awarded to persons groundlessly arrested. And subclause 1 reads as follows: whenever any person causes a police officer to arrest another person, if it appears to a magistrate by whom the case is heard that there was no sufficient ground for causing such arrest, the magistrate may award such compensation not exceeding 1000 rupees to be paid by the person so causing the arrest to the person so arrested for his loss of time and expenses in the manner as the magistrate thinks fit. Subclause 2 says, in such cases, if more persons than one are arrested, the magistrate may, in like manner, award to such of them such compensation not exceeding 1000 rupees as the magistrate thinks fit. All compensation, subclause 3 says, all compensation awarded under this section may be recorded as if it were a fine, and if it cannot be so recorded, the person by whom it is payable shall be sentenced to simple imprisonment for such a term not exceeding 30 days as the magistrate directs, unless such sum is sooner paid. With this now, order to pay costs in non-cognizable cases is dealt as far as section 359 is concerned. And it says, subclause 1 says, whenever any complaint of a non-cognizable offence is made to a court, the court, if it convicts the accused, may, in addition to penalty imposed upon him, order him to pay to the complainant in whole or in part the cost incurred by him in prosecution, and may further order that in default of payment the accused shall suffer simple imprisonment for a period not exceeding 30 days, and such cost may include any expenses incurred in respect of process fees, witnesses and pleaders' fees, which the court may consider reasonable. Subclause 2 says, an order under this section may also be made by an appellate court or by the High Court or Court of Session when exercising its power of revision. Section 360 of the Criminal Procedure Code deals with order to release on probation of good conduct or after admonition. And this is the time, instead of going through this lengthy section, because of first section that you have to read is section 19 of the Probation of Offenders Act. So whenever the Probation of Offenders Act wherever the Probation of Offenders Act of 1958 is made applicable, naturally the question of application of section 360 of the Criminal Procedure Code doesn't arise. Hence, this is the time, instead of reading this section 360, time for you to read the Probation of Offenders Act of 1958. Simultaneously, if you go through this lengthy section, namely section 360 of the Indian Penal Code, no problem. But otherwise now, whenever read, this has got reference to section 19 of the Probation of Offenders Act. With this now, we come to section 361, which says special reasons to be recorded in certain cases. And it says, where in a case the court have dealt with the accused person Now, instead of reading section 360, as per the provisions of the Prevention of Offender Act or the Juvenile Justice Care and Protection of Children Act of 2000, but has not done so. So, if the court, it says where in a case the court could have dealt with, so court would have dealt as per the provision of Prevention of Offenders Act or Juvenile Justice Care and Protection of Children Act of 2000, has not done so, but that has not been done by the court of law, but court has proceeded as per the provisions of the Criminal Procedure Code, then it shall record in its judgment the special reasons for not having done so. So that is as far as section 361 of the Criminal Procedure Code is concerned. With this now, section 362 says court not to alter judgment, and it says save as otherwise provided by this code or by any other law for the time being in force, no court when it has signed its judgment or final order disposing of the case shall alter or review the same except to correct a clerical or arithmetical error. So otherwise court not to alter, court has got no power to alter the judgment as far as section 362 is concerned. Now, copy of judgment to be given to the accused and other persons is made very clear as far as section 363 is concerned, which says when the accused is sentenced to imprisonment, a copy of the judgment shall immediately after the pronouncement of the judgment given to him free of cost. And subclause 2 says, on the application of the accused, a certified copy of the judgment, or when he so desires, a translation in his own language, if practicable, or in the language of the court, shall be given to him without delay, and such copy shall in every case where the judgment is appealable by the accused be given free of cost. With this now, there is a proviso to the section which says provided that where a sentence of death is passed or confirmed by the High Court, a certified copy of the judgment shall be immediately given to the accused free of cost, whether or not he applies for the same. Subclause 3 says, the provisions of subsection 2 shall apply in relation to an order under section 117 as they apply in relation to a judgment which is appealable by the accused. Subclause 4 says, where the accused is sentenced to death by any court and an appeal lies from such judgment as of right, the court shall inform him of the period within which, if he wishes to appeal, his appeal should be preferred. And subclause 5 says, save as otherwise provided in subsection 2, any person affected by a judgment or order passed by a criminal court shall, on an application made in this behalf and on payment of the prescribed charges, be given a copy of such judgment or order or of any deposition or other part of the record, provided that the court may, if it thinks fit, for some special reason, give it to him free of cost. Subclause 6 says, the High Court may, by rules, provide for the grant of copies of any judgment or order of a criminal court to any person who is not affected by a judgment or order on payment by such person of such fees and subject to such conditions as the High Court may by such rules provide. Section 364 says judgment when to be translated, and it says the original judgment shall be filed with the record of the proceedings, and where the original is recorded in a language different from that of the court and the accused so requires, a translation thereof into the language of the court shall be added to such record. And then The last section 365 deals with Court of Session to send copy of findings and sentence to district magistrate, and it says, in cases tried by the Court of Session or a chief judicial magistrate, a court or such magistrate as the case may be shall forward a copy of it or his finding and a sentence, if any, to the district magistrate within whose local jurisdiction the trial was held. This is regarding judgment. With this now, if the judgment is by the Court of Session, and the Court of Session has come to the conclusion that the case, the accused was charged with an offence for which maximum punishment was death, and the judge has pronounced the death sentence, because the judge has come to the conclusion that it is the rarest of rare case as per the decision given by the Supreme Court in Bachan Singh's case, then that sentence for that now, this for the purpose of confirmation of this sentence, an entirely different procedure is followed, and that procedure is laid down right from section 366 up to section 371 of the Criminal Procedure Code, with which we shall be dealing as far as our next part of the lecture is concerned. In the same lecture, we will also try to understand if it happens that the accused person appears or is brought to the court, namely if he appears, if he is on bail, or if he is in jail, he is brought as per following the procedure which is laid down right from section 266 up to section 271. But if it is found out by the court of law that because of his state of the mind, that he is a person of unsound mind, as a result of which it is not possible for him to understand the procedure that is going on in a court of law, then the court is guided to follow the procedure that is laid down right from section 328 up to section 339 of the Criminal Procedure Code is concerned. So these are the different chapters with which we shall be dealing as far as our next part of the lecture is concerned.